Hello, this is a video on the Domestic Asset Protection Trust. It's presented by Express Legal Forms. The other names it may be known as are Qualified Spendthrift Trust, often called DAPTS, Domestic Asset Protection Trust, also called APTS, Asset Protection Trust. What is a Domestic Asset Protection Trust? A trust authorized by law to first, provide for protection against creditors attaching your property, and secondly, allowing you to be the beneficiary. The concept behind asset protection. First, creditors can only go after assets that you actually own. Therefore, remove title of the assets from your name, but allow you to have control and enjoyment of the assets. The goals. What if there was a way for you to put assets into an irrevocable trust but still be a beneficiary of the assets? What if your creditors couldn't access the assets? This is where the Domestic Asset Protection Trust comes in. It allows the trust creator, which is you, to be a discretionary beneficiary, and yet the trust assets are still protected from the creditors or beneficiaries' creditors. It's not about hiding assets. Creditors will find the assets. You don't want to commit perjury by saying you don't have the assets because the assets are held by the trust. Is the goal to protect the property, the real property, personal property, and all gains, appreciation, and income thereon. Cash and equivalents, investment accounts, investment real estate, income producing real estate, raw land, gas or mineral rights, personal property, closely held business interests like an LLC, and others. If a creditor cannot reach the assets, then they will not want to spend the money trying to collect. There's no public record, no federal problems. Now more than ever, with the federal government focusing on U.S. taxpayers moving money outside the country, legally and illegally, trend will be towards using domestic asset protection trusts, not offshore trusts. No public record of the trust agreement exists. Low maintenance cost. Domestic asset protection trusts come with the benefits of lower maintenance costs, local trustees, reduced tax filings, fewer federal disclosure forms, and a reduced perception of impropriety. Another goal is to remain the decision maker. You can make all decisions regarding the distributions from the trust. You make all decisions regarding the investment of the assets in the trust. You are permitted to veto any distribution from the trust. How do these trusts protect you? A domestic asset protection trust is an irrevocable trust. Why is this important? When you get in a bind, a creditor comes after any assets that you have control over. In a DAP, you technically do not have control. It is a legal fiction created by statute. It cannot be reached by a creditor. A DAP can't be reached by creditors, including a divorcing spouse. What we're talking about here is the trust creator having the best of both worlds, actually retaining access as a discretionary beneficiary and also protecting his or her assets while the creditor of the trust is a discretionary and not a mandatory beneficiary. He or she can retain the power to replace the trustee. As for the trust itself, it has the additional virtue in community property states like California of segregating the assets out and keeping them separate during the marriage, thereby avoiding the risk that such property or the income and appreciation thereon might otherwise be commingled and be deemed community property in part or in whole. Let's talk about the creation of the Asset Protection Trust. You place assets in a trust. These assets are protected from the creditor. You can draw on and use the assets. You designate the beneficiary. You can be the beneficiary. You can also designate family members, friends, or charities, or anyone else you choose. Documents necessary to form a trust. There are several documents necessary to satisfactorily complete a domestic asset protection trust. You have to have a trust agreement. You have to have two limited liability companies. A qualified trustee is a private trust limited liability company satisfies this requirement. An investment advisor LLC, which allows you control over the trust in many ways. And then there's an affidavit which the states require, which states you are not doing this for any fraudulent purposes. These will be explained later. You create a qualified spendthrift trust with a trust instrument, a confidential instrument. In the instrument, you appoint a qualified trustee. This is defined by state statute. Must be one qualified trustee at all times. You have to have this qualified trustee. The instrument states the trust is a qualified spendthrift trust under the law. It is irrevocable and has a spendthrift clause. Expressly incorporates the law of the state to govern the validity, construction, and administration of the trust. A legal entity authorized by the state to act as a trustee. What is a qualified trustee? It is a legal entity authorized by the law to act as a trustee. A limited liability company formed by you in the state for that express purpose is a qualified trustee. This is your first limited liability company. You as an individual cannot be a qualified trustee. In other words, you acting as an individual. Nor can any other natural person who is not a resident of the state. Nor can an entity that is not authorized by the law of the state to act as a trustee. That is the reason you start the limited liability company. What does a qualified trustee do? He prepares or arranges for the preparation of fiduciary income tax returns for the trust, materially participates in the administration of the qualified trust, and given authority to manage and invest the assets, and has authority to make distributions to the beneficiaries. What powers do you retain? That's you, the trust maker, can veto a distribution from the trust, retains a testamentary power of appointment over the trust assets, can retain income from the trust assets, can receive up to 5% per year of the initial value of the trust or its value determined by the trust instrument, and the right to add or remove a trustee, trust protector, or trust advisor, and the right to serve as an investment advisor. The distribution rights to add and remove the trustee. The settlers, that in other words you, potential or actual receipt or use of principal when a qualified trustee, including a trustee acting at the discretion of a trust advisor other than the settler, makes such distribution or grants such use in the trustee's sole discretion or pursuant to an ascertainable standard contained in the trust agreement. The settler's right, in other words, your right to remove a trustee, trust protector, or trust advisor, and to appoint a new trustee, trust protector, or trust advisor other than the settler. The settler's right to serve as an investment advisor on the advisor to the trust. You retain these broad powers. Even if the trust is irrevocable, the settler can still retain broad powers and broad control, including to veto a distribution for the trust and to hold a special lifetime or testamentary power of appointment. Additionally, you, as a settler, may serve as a co-trustee while also retaining the power to direct trust investments, remove and replace a trustee, and to execute other managerial powers. Now we have to make sure that the distributions from the asset protection trusts are not mandatory, that they're discretionary. As for the trust itself, it has the additional virtue in community property states like California of segregating the assets out and keeping them separate during during the marriage, thereby avoiding the risk that such property or the income and appreciation thereon might otherwise be commingled and be deemed community property in part or in whole. What is an investment advisor? This is a limited liability company formed by you. In other words, another company which you will control, which directs the trustee on investments and distribution of the assets. You, being the only member of the investment advisor company, have complete control. The investment advisor may direct, consent, or disapprove a trustee's or co-trustee's action or inaction relating to investments of trust assets, direct the acquisition, transfer, or retention of any trust investment, direct, consent, or disapproves the trustee's or co-trustee's action or inaction in making distributions to the beneficiaries. This trustee has to follow the directions uh, of the investment advisor, which is you control this company. Thus, you effectively control the trust. The third document necessary, the affidavit. Settlor must execute an affidavit at the time of the transfer affirming the following. The settlor has full right, title, and authority to transfer the property to the qualified spendthrift trust. The transfer of the property to the qualified spendthrift trust will not render the settlor insolvent. Affidavit contents. The settlor does not intend to defraud any creditors by transferring the property to the qualified spendthrift trust. Second, the settlor does not have any pending or threatened court actions against him except for those court actions identified in the affidavit. At the time of the transfer of the property to the qualified spendthrift trust, the settlor is not in default of a child support obligation by more than 30 days. Further, the settlor does not contemplate the filing for relief under the provisions of the Federal Bankruptcy Code, and the settlor has and shall maintain personal liability insurance of at least $1 million or shall provide coverage equal to the fair market value of the settlor's total qualified transfers to qualified spendthrift trusts, whichever is less. How to form a DAP and supporting LLCs. If you desire to set up a domestic assets protection trust in Wyoming, then go to www.expresslegalforms.com and open the video section for asset protection trusts. Thank you for watching. On behalf of Express Legal Forms, LLC, thank you.